I wanted to discuss on this video podcast what is called the Enrolled Bill Rule and its application here in the state of California. In general, the judicial branch of government at the federal or the state levels is generally loath to review the record keeping or procedural practices of the legislative branch of government to determine the validity of a statute. This limitation on a judicial inquiry into the legislative practices is known as the Enrolled Bill Rule (EBR), as opposed to the other EBR that most of us are familiar with, an Enrolled Bill Report prepared for the governor's office. This is the other EBR, Enrolled Bill Rule, and it's a legal doctrine that basically provides that if an act of the legislature is properly enrolled, authenticated, and filed, then it's presumed that all of the legislative steps that were required for the bill's passage were properly taken. And even so-called extrinsic aids cannot impeach that fact. In California, we have a separation of powers doctrine that is actually set forth in our Constitution in Article 3, Section 3. And the reasoning behind the judicial limitation on reviewing the legislative branch enactment process is that the judicial branch does not want to impinge on the constitutionally enumerated power of the legislative branch when it's governing its affairs. Now, there are a number of critics, including myself, of this legal principle, but as recently as 2009, the courts in this state have concluded that the Enrolled Bill Rule is still in full effect here in California. So the Enrolled Bill Report is part of the governing rules between the legislative and judicial branches of state government. And the basic idea is that it ensures that legislative rules and procedures that govern the legislative process are respected by the judicial branch of our state government. So if a legal question is raised in court, whether a bill was passed by the legislature and sent to the governor's desk, then the legal inquiry is whether the requirements of the Constitution in Article 4, Section 8B were complied with by the legislative branch of government. And the provisions of Section 8B include things like the bill was read by its title on 3 separate days in each house, that no bills are passed unless the bill with its amendments were printed and distributed to the members, and those types of things. Now, if these constitutional requirements were not met, in theory, a court could invalidate the statute passed by the legislature. Existing case law here in the state of California provides that once a bill has been authenticated and enacted, it would violate the separation of powers doctrine for a court to use extrinsic evidence to determine that the legislature had in fact failed to satisfy constitutional requirements in enacting a statute. Almost 100 years ago, this doctrine was set forth by the California Supreme Court in the case of Taylor versus the legislature in 1927. And the California Supreme Court there said that a statute that's been properly enrolled and authenticated conclusively establishes not only the contents of the law, but that the due performance of all steps requisite to its passage by the legislature had occurred, and that this is the general law and has long been the rule of decision in this state. So again, this principle is the EBR, the Enrolled Bill Rule. Note that it said that the Cal Supreme Court in the Taylor case said that this has long been the rule of decision in this state. It was actually first articulated in Sherman versus Story, an 1866 California Supreme Court case. And in that 1866 decision of Sherman versus Story, the state's high court refused to consider basically uncontradictable legislative journals, as well as oral testimony received at the trial court, that alleged that certain proposed amendments that had been rejected in the state assembly were nonetheless mistakenly put into the bill by the enrolling clerk of the Senate and then passed. Later in 1901, in the case of County of Yolo versus Colgan, the California Supreme Court rejected a claim that was based on an entry in the Senate Daily Journal. And what the Senate Daily Journal showed that a statute had not received the requisite number of votes, 21, for passage, and in theory was thus invalid. But the court cited the separation of powers doctrine, and they concluded that while the Constitution has prescribed the formalities to be observed in the passage of bills and the creation of statutes, the power to determine whether these formalities have been complied with is necessarily vested in the legislature itself. Now, in later cases, as recently as 1985, for example, a California appellate court decision in Planned Parenthood Affiliates versus Swope, a conference committee, the Budget Conference Committee, proposed to each house a version of the budget bill that excluded a particular section. And the conference committee approval, or the conference committee's proposal of excluding that provision, was approved by both the Senate and the Assembly and enacted. However, due to a staff error, that section had actually not, in fact, been removed from the budget bill. But the high court or the appellate court said that it lacked the power to strike that section from the enacted bill because it cited the salutary principle that had long been established in California, that the judicial branch may not go behind the record evidence of a statute. And so the court ruled that because that provision was, that section was actually in the budget bill and had received the necessary approvals of each house of the legislature, and so it was duly enrolled and approved by the governor, the court said it couldn't do anything and that fact couldn't be impeached by any extrinsic evidence. Now, the California courts have identified one limited exception to the enrolled bill rule that dealt with a local adoption of charter amendments, but that was very limited. Here, the appellate court discussed applicable case law. This was a 1951 California Supreme Court case, People versus County of Santa Clara. And they reviewed a number of the cases, even legal treaties on the enrolled bill rule. And they said, the holding is that if irregularity in the proceedings by the local authorities appears on the face of a legislative resolution, then the approval by the legislature is not conclusive, as it would be if it was not revealed by the resolution. So in the Levin case, People ex rel. Levin versus County of Santa Clara, the Cal Supreme Court said there's this one exception to the enrolled bill rule, and it applies for the reason that the procedural defect in a local adoption of charter amendments was evidenced on the face of a resolution that had been adopted by the legislature. But obviously, this also involved local adoption of charter amendments as opposed to state legislature enacted statutes.